Hello and welcome to the big picture. The conviction of Tamil Nadu Chief Minister, now ex-Chief Minister, Jayalalithaa, after the case was made to drag on for 18 years, has brought to fore once again the laxity in the justice delivery system. That an influential politician or a money bag can just keep on dragging the case at the cost of justice has much been discussed. This has been the case with Lalu Prasad Yadav also, whose case also took 17 years before he was convicted. There are many other cases which are dragging on in different Indian courts with similarly alarming regularity. Meanwhile, following a recent order of the Supreme Court that cases against elected representatives should be completed in 1 year, the government is drawing up a plan to hasten the process of justice delivery. Can these proposed changes to both the role of courts and the police be effective? What are the lessons one can draw from the prolonged prosecution of Jayalalithaa? We will discuss all this today with an eminent panel of guests. I have with me today Dr. Subramanian Swamy, BJP leader and complainant in the Jayalalithaa case, Justice B.A. Khan, retired Chief Justice of the Jammu and Kashmir High Court, K.S. Sachidananda Murthy, resident editor, The Week magazine. Welcome to all of you. Dr. Swamy, it has taken 18 years for this case to be completed. What do you think was the main reason for this delay in the entire thing?
Well, frequent. I think there were 373 adjournments.
373
adjournments. And invariably, the law was, what shall I say, sucked dry in getting these adjournments. For example, Ms. Jayalalithaa once said that the complaint was given to her in English and she wanted it in Tamil. So for that, there was an adjournment. Then she would go and say that the present judge is of a certain type. She would go and appeal on that. There were a variety of things. Then, of course, the DMK also intervened and said that the case should not be heard in Tamil Nadu.
You think that was the right decision?
I don't think so. I think, you see, even judges...
Because the shifting the case from Tamil Nadu to Karnataka, that also caused some delays.
I don't agree, you see. No, delay, yes. But certainly, I think, you see, the Tamil Nadu judges are, when they know that something can go to the higher courts and then go on to the Supreme Court, after all, their careers are at stake in case some stricture is passed. So I think in a case like this, it wouldn't have mattered. And in fact, the bulk of the initial period, the DMK was in power. And
right.
They
were in power when the case was filed. They were in power when the case was filed.
When it was filed, yes, they had just come to power.
Yes.
And then when my complaint, the summons were issued and the investigation was ordered, the DMK made a plea that since I was a civilian, a person without a post, and therefore they would give the public prosecutor, and so the public prosecutor took over. Now, there the DMK, I think, was literally using it to keep her in check. And I think it could have been done within the 5 years they were in power.
What was your motivation?
My motivation for what? Once the court decided that the case will be conducted by the public prosecutor, you see, if it was, in fact, it was only after the Antule case that we really came to know that a private complainant can also be a deemed public prosecutor. In the case in 2G, I am. And I certainly think that I have been a factor that is almost complete within 2 years, the whole case. That time it was taken away from me by the presentation, the prosecution was taken away by the public prosecutor. So there was nothing I couldn't do except that the court would consult me if there was some issue which they needed. For instance, the transfer, when the matter went to the Supreme Court about transfer, I as a complainant had a role to play, and I, of course, thought that, to oppose it would take a longer time, so I supported it. So I think the adjournments is the thing that needs to be somehow, the law needs to be tightened. I don't think adjournments should be given so easily as they are given.
Justice Khan, we have discussed the kind of justice delivery system in the past also. But when such high-profile cases come to the fore, these problems really look very huge because there are so many other politicians being prosecuted across the country, and every time we are seeing that things just get dragged on and on and on. Do you agree with Dr. Swamy that it is the adjournments which caused this, and why do the judges give so many adjournments?
100% I agree with him as far as adjournment is concerned. But dragging on is not specific or peculiar to any politician or whatever.
It is across the board.
Across the board, and it's inherent in the system. And you have so many contributory factors. We can have a separate debate on those contributory factors. For example, in this case, if DMK was power for most of the time, how did all those adjournments took place? Maybe the prosecution was lethargic, maybe the prosecution was taking dates, maybe the judicial magistrate was lethargic, he was granting dates for free, and at the drop of the hat you have adjournments in the system. Now how do you check it? It's not only adjournments, mind you. There are so many factors which contribute to this delay. And this delay happens in almost, that is why our criminal justice system is on the rocks today. It's on a near breakdown point. You have so many under trials in the jails whose conviction period, if sentenced, has expired since. So, either we discuss those, there has been no concrete policy to deal with the matter, and which should have involved raising the number of judges, we should have involved the raising of the infrastructure, we should have raised some stipulation in the law.
We will come to that, sir, because there is apparently a proposal which the government is going to bring up very soon to how to tackle this problem, especially in cases related to high-profile cases of politicians or elected representatives. Meanwhile, we are joined in now by P.P. Rao, a very eminent senior advocate of the Supreme Court. Mr. Rao? Mr. Rao, can you hear me?
Yes.
Okay, Mr. Rao.
Yes.
We are taking the case of Jayalalithaa, which has taken 18 years for prosecution. In this context, why do cases get delayed so much? I have Dr. Subramanian Swamy here also on the panel. He feels that the adjournments which have taken, there were 373 adjournments apparently according to him in this case itself. And he feels that shifting of the trial from Tamil Nadu to Bangalore itself was something which he is very skeptical about whether that needed to be done. But we are talking about why these kind of delays take place. Is it because these high-profile people are able to manage the judiciary and ensure that it keeps getting dragged on?
I would like to remind you about another case.
Yes.
That is the Ayodhya demolition case, Babri
Right.
Masjid demolition case.
Right.
Demolition took place on 6th December 1992.
Right.
And the matter is still lingering.
Yes. 22 years now.
I'm sure the other participants will appreciate how it happens now.
Right.
So, and I would like to point out one more thing. How many times the cases on some aspect or other go up and down up to the Supreme Court and again down travel to the trial court.
Right.
How many times these things have gone up to the Supreme Court and came down from there to the trial court. That also is a factor to be taken into account.
Right.
And also, Mr. Subramanian Swamy rightly pointed out, transfer of the case from one court to another state, to another court. That involves transferring entire documents.
Right.
And then rearranging the whole thing.
Right.
And appointing a new public prosecutor. And various things have to be done. So therefore, naturally, these things do take place. And also accused as a general tendency, you will find, they seek adjournments. That is universal it is, not peculiar to any particular case. In every case, general tendency accused is to postpone the evil day as much as possible. So they tend to take adjournments. And one more thing is, we require a stronger judiciary than what we have to deal with these cases sternly and to ensure speedy trial of the cases. The Prevention of Corruption Act contemplates day-to-day trial, but then that doesn't take place as a matter of rule. It is only an exception that day-to-day trial takes place.
Right.
So therefore, the system requires overhauling. And that is because we are not able to provide speedy criminal justice. That's why the incidence of crime is going up.
Absolutely.
And people are suffering a lot.
Absolutely. Okay, I'll come back to you, Mr. Rao. Sachi?
Yeah.
In the case of in the case of Jayalalithaa, you know, there were several hurdles. Very interestingly, Justice Khan points out that the first 5 years it was the DMK government which was there, and any delays which took place, they are also partly responsible for it. What kind of play takes place in this kind of thing? You have been observing this case, and you have been talking to a lot of people from both ADMK and DMK. How do you look at this?
Yeah, Girish, first of all, I also would like to use this time to congratulate you. It was your cover story, which was in 1992. You wrote about Jayalalitha's amassing wealth and cellular function. So, I mean, I think you had paid your own consequences for that, but that's a different thing.
The very first year.
Very first year, sir, 92, sir. So, I mean, I would just like to bring it into perspective. But I think this case, I think, as Dr. Swamy said, they wanted to use the political clout against her, use this case, dangle it. But also, what I understand was that at that time...
Incidentally, we have to also remind everybody, and Mr. Dr. Swamy also, about his progress through the case when she was first his foe, and then his friend, and then his foe again.
That I made it clear to her when she came to see me to have an alliance. I said frankly that on cases I will not withdraw any of the cases.
That's interesting.
That's what.
And I pursued it. I appeared in court, and she knows that the speak case I won the speak case in the High Court.
Yeah, he did that.
Okay.
But then I think, the first few years, because the reason is after the court order that the case should be registered and she should be summoned and all that, then the DMK government said we have to investigate and file a pakka charge sheet. That took a little time. And then the power changed in Tamil Nadu. Jayalalithaa came to power.
And then she became chief minister, then had to leave, and then had to come back.
There was an apprehension that the whole investigation, its prosecution will be scuttled. So then this petition was moved that the whole case should be taken out of Tamil Nadu. So, I mean, there were at that, and in the 90s, there were very strong apprehension that because she had trampled several other cases which were ongoing and all that. So, they had a reasonable apprehension, DMK. That's why they went to the Supreme Court and it was shifted. But when it shifted
You think that was the right thing to do?
I think that was the right thing. In the prevailing atmosphere in Tamil Nadu at that time, it was the right thing. Because the Supreme Court was satisfied that there was a genuine apprehension that the case will not be this. It's like, I mean, there was another case where, Jayendra Saraswati, the murder charge against Swamiji was shifted to Pondicherry. So, like that. So, that
and
is
even
the
in Gujarat case, it has been shifted
my
to
thing
Bombay.
was the Supreme Court, after it shifted it, should never have entertained any appeals, any interlocutory applications. How many interlocutory applications were in this case? If you could look at it, and the time of the judge will be taken up. Special public prosecutor would have to respond to that, time given and all that. I mean, the larger the battery of lawyers who were employed by Jayalalithaa, more of these each witness is to depose, some IA will be filed.
Right.
So, and in fact, the other way, if only Jayalalithaa had got this judgment delivered a year ago, she wouldn't have suffered the consequence of the Rahul Gandhi ordinance, this thing. She could have got into appeal, whatever it is. Now she has lost that also. Anyway.
So thanks to Rahul Gandhi.
Not thanks to Rahul Gandhi, I'm sorry to say. The president would have turned it down. He also had that information.
Okay. Yeah. Anyway, I mean, that's not the issue under discussion now.
Yeah.
I'll come back to the original issue. Now the government has proposed. Government has apparently going to propose, because the Supreme Court itself has come out with an order saying that these cases should be, finished. The trial should be finished in 1 year. You think it is a reasonable? It's reasonable or possible to finish this kind of trials in 1 year?
I think one amendment in the law would be good, that cases like corruption, murder, rape, the accused whose charges have been framed should not get any bail. You see, even the charge sheet has been filed by the police, he should not get bail. Now, once that pressure is there, then the accused is not under, he doesn't feel that delay is good for him.
Right.
So that's one thing we.
But that doesn't seem to be there.
No, that's
part
not
of the
there
proposal.
in the law yet. Yes.
That's not yet part of the proposal. Yes, Justice Khan?
No, that can't be. That can't be.
You can't have that kind of a law.
You can't deny a right of bail to a person. It's a question of
No, but
liberty, and our system is based on that the accused is presumed to be innocent
Till
till he is
proved
convicted.
No,
Now, how can you have something
but
that you don't deny bail in a particular
he's
case?
considered prima facie guilty when the charges have been framed.
No, that is the outlook of the court to see.
No. Once the charge is framed, it is clearly prima facie. Otherwise, even the summons would not, the warrant would not be issued.
Let us get Mr. Rao. Mr. Rao, how do you look at this? Is Dr. Swamy's proposal, is it viable?
It is not consistent with the concept of rule of law.
Yeah.
Rule of law postulates punishment follows trial, and non-denial of bail would amount to punishing a person before trial. That is contrary to the entire criminal jurisprudence.
Right. Okay.
So any such rule, if it is made, I doubt it will stand judicial scrutiny at all.
Okay. Mr. Rao, I'll come to you.
Article 21 of the Constitution guarantees right to life and liberty,
Right.
except in accordance with the procedure established by law.
Okay. Mr. Rao, that one of the proposals...
So we cannot,
But let me say
take away
that I
judicial
was
power
restricting it
to grant bail.
to crimes against society like murder, rape and corruption.
Not uncorruption. Anyway, Mr. Rao, that's a.
Crime-
I'm sure there
crime
will
is
be a.
crime.
In case there
Yes,
is any such
principles
proposal,
of
we can
law
have a
apply
separate
to
debate
all
on this. No, Mr. Rao, I want you to answer another question. The proposal of the government apparently, after the Supreme Court has come out with this order saying that in 1 year's time these cases need to be finished. One of the things which they are saying is that there are two ways. One is restrictions on the police and other restrictions on the court. If in 3 months the investigations are not finished and charge sheet filed, the SP who is in charge of the district where the case has been filed will be held responsible and he will be punished. You think this is something which can work?
Yes, but it should not be a mechanical rule. For every rule there are exceptions. There are cases and cases which involve a huge amount of investigation. So we cannot have a rule of the thumb like that and then strictly enforce it.
Right.
It is ordinarily should be so, but subject to just exceptions.
Okay. What about? I'll come back to you, Justice Khan.
In the case of the courts also.
In the case of courts also, the district judge will have to monitor all the cases and ensure that there are no unnecessary adjournments and the cases are finished in time. You think that's also, is that something which is possible in the present circumstances?
It is possible. It is possible, but subject to exceptions. We cannot take away judicial power and judicial discretion in exceptional circumstances. So therefore, with saving that, protecting that discretion of the judicial discretion, then we can make a rule and enforce it.
Yes.
But we cannot altogether take away the discretion of the court to grant adjournment.
Okay.
I think, as you said, there should be a separate debate on this question. But I would like to say that even fundamental rights are subject to reasonable restrictions. So now, what is considered reasonable, the courts will decide. And I think this is something that the government, the proposal I made about on bail, should be tested in the courts, if nothing else, you see.
Justice Khan, making the SP of the district accountable, making the district judge accountable, you think it is practical in the kind of circumstances which we have?
Girish, I welcome accountability if it is fixed somewhere. But question is, you have to have a situation which is suiting that accountability. For example, you may have a commission of an offence, investigation of which may take more than 3 months. Or, for example, district judge, if you make him bound, that you have to monitor and see that this, then he has to ensure that for this kind of a case of a politician, I have to spare a magistrate separately. He should not have
Every high court is supposed to have special cells to monitor all these things. I'll come to
you may have cell. Cell doesn't matter. Question is, if a magistrate is burdened with 60 cases and then he is told to conduct a day-to-day trial of a politician's case, how is it possible? unless you take away those 50 cases from his roster. That's not possible. Question is of a management. Question is of this can become workable only, I am talking about the judicial side, if you have a separate class of judges dealing with these kinds of offences, just as we have special courts for some offences.
This was also a special court. It took 18 years.
That's no. It took 18 years because you have a strategies being adopted by all sides.
There's a difference.
Exactly.
There's a difference.
One second, sir. Let him.
There's a difference.
Yes.
In the 2G on which I was also a petitioner, the Supreme Court decided that no appeal against an order of the special court will be entertained except by the Supreme Court itself. Now, I am sure that at that time P.P. Rao also said that individual liberty, this is what
No, but that only
Constitution.
Supreme Court can do.
But the Supreme Court, yeah, that's precisely what I'm saying.
No other court can do.
Even on
High
these
Court can't
restrictions
do.
that I'm talking about, except, for instance, on bail, these need to be tested. And it should be tested by the Supreme Court.
Yes, Sachi.
No, Girish, firstly, this proposal that complete trial within a reasonable time, that is, the Supreme Court once said that do it in 3 years. If a trial cannot be completed in 3 years, then the case will be discharged. Then, do you know who went in appeal against it? It is the CBI. CBI said no, because this will help the defendants to manipulate things and all
Manipulate
that.
things.
Yeah. But then second point mine is, you said the government is saying that we want against politicians, those in power, 1 year. But then the Chief Justice who retired yesterday, Justice Lodha, he said no, but because it's a right of equality, every case has to be treated equally. Then third point is...
No, unless, as Justice Khan says, there is a special court established with a judge who can handle only these cases.
The question is, why a special court for a politician? Just because he's been elected. And what about the other ordinary people who are languishing for years? So then the third point is on the responsibility of the SP. Now, as you know, in our country, the SP is a creature of the government. He is there at the whims and fancies of the chief minister or the district minister, local MLAs. Unless you have total police reforms where the SP is autonomous and is given entire powers as well as is made totally accountable, you can't do that because SPs want to get out of districts. The politicians want to get them out. So all this, unless you have a reform, otherwise you can't make them accountable.
Yes.
You see, the United States, things move faster because they have this discovery and interrogatory procedures even for criminal. We have it in our civil procedure code, but we don't have it in the criminal law. That means that most of the things that we spend hours in the court come in the form of written affidavits.
Right.
And then they are examined by both the counsels, and then it comes up for the trial. And so the trial is very much shortened.
Mr. Rao, all the problems pointed out by my other panelists in the thing. Would you agree with this? You know, having just making somebody accountable without giving them the freedom and the autonomy to function can become disastrous.
Yes, I agree with the suggestion that there should, first of all, we must carry out policy reforms.
Right.
Of which already there is a judgment of the Supreme Court.
Right.
Only it has to be fully implemented. And there are some problems of implementation, still the matter is pending in Supreme Court.
Right.
That should be resolved. And I think one thing can be done by the central government, at least in areas where the ruling party is in power, and also union territories. They can implement these police reforms straight away. And that will send a message to other states as well. Unless you separate investigation from prosecution and ensure autonomy for the police to function independent of the political bosses who control them now. Unless you do that, the criminal justice system cannot improve. And this will be a major reform which the people will welcome, and that will automatically bring down the crime rate.
So it's much easier said than done, ultimately.
Everything good is much easier said than done.
Justice Khan, very quick last words to you.
Girish, it all comes to implementation. We have so many good things to say, but when they are not implemented on the ground, they fail. That is what is...
And these kind of things drag on, cases can keep
and
getting
by
dragged on.
strategy from all sides.
Strategy from all sides. You pointed out.
No, but then I want to point out
Very
one quickly.
yes.
One is what just Dr. Swamy said, that he was there. So he said he ensured that the 2G case did not go off the rail, and Supreme Court was monitoring, which is unfortunately not the case. But then we had in India a corruption trial which went very fast. That was the JMM trial, except for a interpretation of the constitution by the Supreme Court that the MPs can do anything on the floor of the house, they cannot be held accountable. Otherwise, that was one of the fastest
trials.
corruption trials I've seen.
Okay, I think on that
Thanks to
note,
them putting the money in the bank.
Yes.
which made investigation easier, which won't happen in every case. I think we have to end the program, but the fact is that this is something which is much needed, then everybody agrees with it, but how it is going to be done, how it will be implemented is something which I think we'll keep discussing. Hopefully, the government with new proposals will be able to find some solutions to this. Thanks to all my guests, Dr. Subramanian Swamy, Justice Khan, Sachidananda, Murthy and P.P. Rao. Please keep watching. We'll come back with another issue on the big picture same time tomorrow.